comments for questions on what they were interested in. And so got a number of interesting requests. So I'm going to be talking about chatbots and how they, the use of chatbots intersect with rights of publicity. I'll explain what that is. Got a question on how does indemnification for infringement and potentially getting insurance coverage for that, how does that work? How does indemnification work? So I'll be talking about that. Fielding a question on chatbots and trademark infringement in general, how one gets in trouble or stays out of trouble in the use of the chatbot, vis-a-vis trademark liability. The issue of what happens, what constitutes a trademark license, what happens if someone appears to be letting you use their trademarks, but you haven't necessarily have anything in writing. How does that work? And then a few remarks on what I see some of the main issues for the use of chatbots in social media applications. So, rights of publicity are they're a creature of state law in the United States, and they vary from state to state. And what they do is they can protect the use of names, likenesses, voices, and other identifiable aspects of identity. And so, obviously, if you have a chatbot that uses or appropriates a portion of the likeness of someone famous or non-famous, depending on the state in which the person lives, you may have to deal with this person as someone demanding compensation. As I said, the laws in the United States vary from state to state, so you're not going to get uniform treatment. If you're dealing with somebody who lives in New York, it's a very different legal landscape. Perhaps somebody, if you appropriate the likeness of somebody living in Pennsylvania versus New York or Indiana or Tennessee, Tennessee has very strong rights of publicity because of Elvis, which I just think that's a nice thing to note. And the international landscape is similarly varies on the degree of protection. So that is sort of a cue that if you're going to be, if you know that where the person lives, you're thinking about appropriating that license. That's a good point to consult a lawyer familiar with the laws of that particular jurisdiction. These rights can also be both under the common law, that is, just arise from court decisions, and but also in many states there are statutes on the books that explicitly set forth the parameters of these rights. Oftentimes, these states they are viewed as personal property rights, and once you have a personal property right, that is something that can be passed by inheritance. In Indiana, is famous for having the broadest set of rights of publicity in the world, and those rights exist for 100 years after the death of the person whose likeness or likeness things are at issue. There's a famous, I say, there's identifiable aspects of the person besides the likeness. There's a famous case around here. Anybody that used to watch NFL films, John Facenda, called The Voice of God. He had this deep baritone voice, and he'd say things like the frozen tundra at Green Bay's Packers Stadium, or Lambeau Field as they call it, and that was held as a protectable item of his identity. And usually there are exceptions for non-commercial uses. So the best way to get in trouble with a chatbot appropriating somebody's license is, if it's a hardcore commercial use, as opposed to something that's more educational or scientific or research. There are significant protections that arise under the First Amendment of the United States Constitution with respect to rights of expression. So if you, especially to the extent that you are doing something with the likeness that is transformative, what they call in the legal doctrine transformative. What do I mean? Well, if as a rule of thumb, if the likeness is extremely lifelike, and you have done nothing other than just sort of carbon copy the likeness, depending on the graphics or whatever that may or may not be possible, and you're just simply making it a commercial exploitation of this famous likeness, you're more likely not to have First Amendment rights of expression. However, if it's a caricature, if there's parody, if there's satire, if there's some kind of commentary, you have a better chance of asserting a First Amendment right. And again, unfortunately, these are very fact-specific determinations made by the court. So it's difficult in every case, for me to like stick a quarter in, you get the right answer. It depends on the context, of the particular body issue. But that's the parameters of the issues that the court's going to look at. I want to say a few words about infringement indemnification. And so if you have, well, what is indemnification? Indemnification typically means an agreement to pay a sum to compensate for loss suffered by another party. So a lot of times in complicated commercial relationships, you see it a lot of times with technology and software where there's potential liability for intellectual property infringement. The customer says, okay, I'm going to use your software, right? I'll run it on my machines or I'll have it in my shop. But if I get sued, if it turns out that your software infringes somebody's patent or you didn't have the right to use it and I get sued, I want you to hold me harmless. I want you to pay the bill, depending on the parameters of the agreement. Sometimes this can also involve an agreement to pay to retain a lawyer and actually have that lawyer conduct the defense, or sometimes you're just picking up the legal bills too. This right to indemnification can arise by contract, and in my world, usually that's what I'm dealing with because the parties are sufficiently sophisticated and to know that if a client comes to you and says, you know what, I have the rights to use Albert Einstein's likeness. I'm just going to pick out a random famous person. I want you to create a bot that's very lifelike, and I want you there. You should be thinking, okay, you do have his permission or his heirs or his estate. I don't know what the status of his estate is, but in that kind of situation, you would want some assurance. You would say, look, I want you to hold me harmless if his heirs come after me as a contributory infringer, as a person who created this thing. There is also a common law right to indemnification for infringement recognized. So that is, even without a contractual agreement, if you get hit with a judgment from a court for copyright infringement or what have you, you would, if you can make out the case that it was somebody else's fault, you can get indemnification that way. Now, common law and contractual indemnification rights are not always meaningful where the indemnifying party has no assets. So, if it's just a one-man shop or just a natural person without substantial assets and you get hit for $1 million verdict, it's really cold comfort. So it is often the subject of, it's an insurable risk, or it can be. So there is coverage you can get. Those policies often require the loss to actually have been paid out for you to make the claim. So that's something to be careful about or see the parameters of your policy. But that is, Richard, I think that was one of your questions. That is a way. That is a prudent way often to deal with this business risk. A few words about chatbots and trademark infringement. To what extent could the use of a chatbot get you in Dutch trademark infringement? Well, trademarks are words, symbols, phrases, devices, or combinations thereof that identify the source of a product or service. When it's a service being identified, they're called a service mark. So the Nike swoosh, a tagline, like "That's hot," or a combination of that, the swoosh plus "Just do it," You know, all those things, mixing and matching, you can slice and dice them, but those are examples of trademarks. Also, they're the look and feel of packaging. So just to pull something out of the air, you know, the Mr. Clean cleaning product with the genie, I think, you know, that is called trade dress, right? That is the combination of just shape of the packaging, the color, especially those things that are non-utilitarian. You can't claim trade dress protection in your package because it is a rectangle, for example. You know, that is common packaging size. So infringement, trademark infringement arises when a mark creates confusion. And when you're using a mark that creates confusion in the minds of the relevant consuming public about whether you're associated with some other manufacturer. So if I started selling shoes and athletic equipment and I had, you know, some kind of zigzag, or I used 3 stripes, you know, I might hear from the Adidas people. You know, especially if I chose a 3-stripe design and I chose a name that was, or catch lines or tag phrases, you know, that were similar to what Adidas was doing. So that is both under state and federal law. You know, that is trademark infringement. Now, to the extent that your bot, you know, is incorporating marks and things like that, you can see very well how it could. You have you know, a potential issue there. Other related causes of action include blurring by dilution or dilution by blurring or tarnishment. What does that mean? That means you're using mark. It's not necessarily confusing. But it reduces the strength of the mark. So what do I mean? Well, let's say I had, you know, everybody knows Microsoft. So let's say I started to use the word Microsoft to sell knit sweaters. Okay, it's very unlikely that, especially if I didn't use if I just used the word and I used other symbols and phrases around with it, very little likelihood that someone would be confused that this was Bill Gates' next, you know, philanthropic venture or whatever. But if it was allowed to, if people were allowed to do it enough, it would dilute the strength of the mark, because there'd be a zillion Microsofts being run around there. There's Microsoft bicycles, Microsoft basketballs, Microsoft knit sweaters, right? So there is, for a famous mark under federal law, there's that cause of action. Blurring by, or dilution by tarnishment is where you use a mark in a way that is offensive. So if you have a, you know, a lot of times these cases about dilution by tarnishment arise where somebody uses a mark or similar, you know, in parody fashion with some kind of off color or you know, adult entertainment angle or something like that, and the mark owner comes in there and says, you know what, we're a church group. I don't appreciate, you know, you're using the same name with this adult, you know, as our church with something that's unsavory, right? And obviously these are things, when you use a bot, you have to think about, you know, if you're sort of close to some mark out there, that somebody might take offense. False designation of origin and false advertising are other potential things you can get in Dutch for, to the extent that the bot creates the impression that some person or organization or mark holder is endorsing whatever it is that the chatbot is being used for. That is considered false designation of origin. You are, you know, Major League Baseball is going to get mad if you know, you're using a bot and it has, you know, licensed marks incorporated into it, and it's suggested or implied from the way you're using it that there's some sort of affiliation or endorsement. So that is something to you know, be careful about in the use of a bot there.